There are two types of custody in California. There is legal custody and physical custody. Legal custody has to do with the decision-making power a parent has over their children, having to do with doctors, dentists, psychological help if your child needs it, special needs decisions for special needs children, choices of school, choices of religion, choices of extracurricular activities for your children. Those all fall within the guidelines of joint legal custody. The idea is that both parents, during a divorce and after a divorce, will still share this joint legal custody of their children. It's not based on a percentage. You can't say one parent has 75% and one has 25%. If the parents have joint, they have 100% power to make decisions. However, they need to do it together. If they don't do it together, the court will have a problem with that. And if you are difficult to work with the other parent in joint legal custody decisions, you run the risk of losing your joint legal custody powers or having them limited. The other custodial decision or issue is physical custody. Physical custody is a much simpler issue. That literally is who will have possession of the children, and that does involve a timeshare. One parent might have primary physical custody, the other secondary physical custody. It has nothing to do with the decisions to be made for your children. You will still, with joint legal custody, share that right with the other parent, even if you're seeing the children on alternate weekends. So it's very important to distinguish the two, because physical custody not only has to do with timeshare, it also plays into decisions or court orders for child support, because they will look at the physical custody timeshare between the parties. Again, not so with legal custody, which frankly is the more important one. You always want to be able to participate and make decisions that are for the best interest of your children. That is legal custody. The best interests of the children are what will keep the children protected and safe and happy. It means being able to provide for them all the basic needs that they need for food, for shelter, for happiness, and to be educated. It means protecting them from anything that may put them at risk. That may include having to go to court and protect the children from the other parent at times. It does arise in family court quite a bit. Those best interests, though, are what the courts are centered on when there are children involved in a dissolution of marriage. That is number one for the courts. What is in the best interests of the children? The way you change custody orders is you have to go to court. You can do so by voluntary agreement with the other parent. You can write up a stipulation as to what you change and what you want to change for custody orders, and that is the best way to do it. The other way is when you don't have an agreement, you go to court anyway and you file what's called a request for order, and you make your argument as to why I need to change custody orders. What is in the best interests of those children? You're able to do it both before and after a judgment. After a judgment, it's a little more difficult. You have to show the court that there's a material and substantial change in circumstances with the facts surrounding your child and you and the other parent that show that an adjustment, a modification is needed to protect those interests of the child. Well, you can move with your child after divorce, yes, but there are certain rules that must be followed. One, it's advisable that you have primary custody of your child first. If you don't, you're in for a hell of a battle. But let's say you do have primary custody of your child. You must give certified mail notice to the other parent 45 days before the date of the move. That's required by the state of California. That gives the other parent 45 days to go to court and file an action to prevent the move. If they don't do it, theoretically, you can move with your child. Let's say you don't give notice to the other parent that you're going to move with your child and you move out of state. Well, the court doesn't like that. The other parent can go to court saying, I never got notice, and the court can order that you return the child and put the child in the custody of the other parent for your not following the rules. Or worse, you can be arrested for kidnapping. If you are going through custody issues, legal custody, physical custody, if you can't get the other parent to agree, if all attempts to negotiate and work together have failed, come to us. We're the experts on this. We can get you into court. We can get the judge to listen to your side of the story. We can get the other parent to understand, maybe through a court order, that your concerns about your children are legitimate. We're here to fight for you for that.